Hi, and welcome from the Federal Bar Association for the Western District of Washington. My name is Jamie Lissagore, and I'm the current Vice President. This is a webinar program on the Western District of Washington's court operations during the COVID-19 emergency. Membership in the Federal Bar Association is what makes these programs possible. So if you're not a member, we ask that you consider joining. And if you are a member, don't forget to renew your membership this June. A couple of technical notes before we begin. There's a space called Q&A where you can enter your questions, and we will be monitoring those and addressing them as we go or toward the end of the presentation. If you have technical issues, please reach out through the chat function. We have an administrator on hand who will field those issues. And we're also recording this event, and the link will be circulated to our members in the near future. So it's a great privilege to introduce our two speakers this afternoon. These two individuals are very well known and respected by the bar, so I'm going to keep this very brief so we can focus on the important issues at hand. Chief Judge Martinez was appointed to the federal bench in 2004 and assumed the role of Chief Judge about 4 years ago. We're also joined by Bill McCool, who is the District Court Executive and Clerk of Court for the Western District of Washington, a position that he's held coming on a decade. Both Chief Judge Martinez and Bill have been working tirelessly to ensure the safety and health of the court and the court family, the parties, the bar, and our community since the outset of this crisis. They've been at the forefront of developing best practices and efforts for coordination among the courts in the Ninth Circuit and across the country. I know I speak for all of the bar in thanking you and the rest of the court for the thoughtful way that you've been handling this crisis, including by providing clear communication on the current state of affairs. And we certainly thank you for making the time to talk to us today, and we're looking forward to hearing more from you. So with that, I'm going to turn things over to Chief Judge Martinez for opening remarks.
Jamie, thank you so very much. And good afternoon to all of you logged into this webinar today. I hope all of you are healthy and doing well. 2 months ago, almost exactly, March 13th, also a Friday the 13th, I was at the Seattle courthouse in my chambers, meeting with my chamber staff as we normally do on a Friday afternoon. We had no idea at that time that our lives were about to be completely upended by this novel coronavirus. Given everything that's happened to our court, our community, and our country, that day seems almost like an eternity ago. These are truly unprecedented times as we struggle to maintain some semblance of normalcy and to assure the public that the institution of their courts is still operating. The people in our cities, our communities, and our district need to know that justice is too important for us to completely shut down. However, as Chief Judge, I firmly believe that the health and safety of every person in our courthouse, whether staff or visitor, is the #1 priority, especially since we were the hardest and most initially, hardest hit and initially the first hit in America. So like everyone else in our community, I think what happened following that, we hunkered down. We were the first to issue a general order basically about reducing the presence of humans in our courthouse. At the same time, we knew we had to keep some of the essential matters absolutely going. And that includes, of course, the majority of our criminal cases, especially the ones handled by our on-duty criminal magistrate judges. New arrests, people being detained, those had to be dealt with. We had to come up with a mechanism to do that. We had to maintain those essential hearings. We put in place a series of weekly conference calls with all of the stakeholders involved. I think we're up to #9 now. We've been doing it now every week, and we just handled #9 on Wednesday. That communication and cooperation has been essential. All working together. We have made incredible strides from IT people, from the courthouse, from the Federal Public Defender's Office, U.S. Attorney's Office, everyone. We managed to be able to work together to make sure that we could keep some of these, like I said, essential services operating, while at the same time safeguarding everybody's health. We've handled probation hearings, sentencings, pleas, revocations, compassionate release motions, all sorts of things like that. Our probation and pretrial people are the equivalent of our frontline people. 70% of a probation officer's job is in the field, being in the community, meeting with other people. That became very, very difficult to do and safeguard them at the same time. We had to come up with mechanisms to make sure that people could be supervised as they need be, while at the same time protecting our probation people. The U.S. Attorney's Office was very instrumental in helping reduce the pipeline in and also in helping increase the pipeline out of people that were in detention. Of course, many of the federal correctional institutes and federal detention centers around the country started getting infections with COVID, and that also created all sorts of issues. So we were initially, I think, the first hit, but the entire country soon followed. You know what I'm most proud of, though, in that entire time, in the last 2 months? I am most proud of the fact that because of the immediate steps that we took, not a single person in our court family, not a judge, not a clerk, not a U.S. attorney, not a federal public defender, not a probation officer, marshal, CSO, no one has tested positive for COVID-19. That is not the same around the country. Around the country, you already have almost 80 people in the federal judiciary that have, and the court family, that have tested positive. We've had 38 CSOs test positive. We've had 2 contract workers test positive. We've had 2 CSOs pass away. You know what our biggest challenge is right now? Our biggest challenges lie ahead. How do we get back to normal, whatever that new normal may be? How do we reconstitute our court? And that is basically what the subject of this particular webinar is today. The most important thing, I believe, is how do we start up jury trials again? When and how can we assure people that come in as potential jurors that they will not become infected, and 2, that they will not take an infection home to their loved ones? We started up a reconstitution committee. It's led and chaired by District Judge Ben Settle out of Tacoma and Bill McCool, who you'll be hearing from today. The whole question before them is, what do we do now? And how do we prepare now to get ready for that day when we are able to bring jurors back into the courthouse? I want to thank the Federal Bar Association and each of you listening today. We are all in this together. The opportunity to re-examine perhaps how we do things is before us right now. I'm not sure that we will ever get back to the way it was before. And maybe this is a good opportunity to think, can we do it better than the way we were doing it before? So all of these great minds that are focused on these issues and these problems, I'm hoping something good, something positive comes out of this. By March 13th, 2 months ago, people in King County were already dying from COVID-19. And that has happened every single day until yesterday. Yesterday, not a single death was recorded in King County. Unfortunately, we had some deaths in other counties, but that is a monumental step forward for us. We're hoping that we can keep that going. It gives us hope for the future that we can get back to opening up our courtrooms, to be able to have trials like we did before. So I want to thank each and every one of you for watching this, and I hope you enjoy this webinar. Jamie, thank you.
Thank you, Chief Judge Martinez. We really appreciate those remarks, and certainly a lot of interesting discussions and challenges that we're going to need to look to the future. And so with that, I'm going to have a sort of moderated question and answer format discussion with Bill McCool. So just right now, I think most of us as lawyers are working remotely from our homes and haven't been to the office maybe in months. Over at the courthouse, what does life look like right now at the courthouse, and what restrictions and safety measures are in effect there at this time?
Well, thank you, Jamie. First of all, welcome everyone to this webinar. It's always a pleasure to speak with the Federal Bar and the lawyers who work so hard to serve our court and your clients. Right now, the courthouses are pretty bare. There are very few judges and staff coming in to Seattle and Tacoma each day. We have clerk's office staff coming in to process mail payments and anything deposited in our drop boxes. And that's been a pretty steady flow of things. A few judges come in each day to retrieve mail and documents or conduct remote criminal hearings. And beginning today, everyone in public and common areas is wearing masks and face coverings. And personally, I find that very reassuring to see all the CSOs, marshals, and everyone in the courthouse and public areas wearing masks gives me some comfort. The court offices remain closed, and members of the public come into our courthouses, however, to use the drop boxes. Any member of the public that doesn't have a mask will provide one for them.
Great. So I'd like to start with the big question that I think Chief Judge Martinez touched on, which is jury trials. We know that those have all been suspended for the near term. I'm hoping you can speak to us about what the challenges are in convening juries and the court's current thinking on how and when this will happen.
Of course. Chief Judge Martinez entered General Order 08-20 on Wednesday. Those of you on the bar who are signed up for our ECF system got an email blast from us, and you'll note that the order continues all in-person proceedings, grand and petit jury matters, and speedy trial calculations until Monday, August 3rd, 2020. That's the date that we're working towards now for reconstitution of our court in Seattle and Tacoma, and we are hopeful to keep that date and make it happen. There are many challenges to conducting trials and really any in-person court matter. But most importantly, we want to follow all of the recommended health and safety measures to ensure all the participants in a court proceeding are safe and secure. We're working towards reconvening our grand jury panel the first week in August. That's our aspirational date. This will be a good test for us on bringing jurors back into the Seattle courthouse. We've set aside a large courtroom and have converted it into essentially a grand jury room and suite. We're going to survey our grand jurors and communicate all the health and safety measures that we will implement. And we're going to ask them about their issues and concerns about travel, parking, service, etc. Then I plan to contact each one of them personally and assure them that we will make their service safe so they can fulfill their duty. As for petit jury trials, that will depend on many factors, but we want to resume those trials as soon as possible after we reconstitute.
Great. So let's take a closer look at criminal proceedings, since those generally are taking priority. What proceedings are going on now, and how do you foresee reconstituting criminal proceedings as we move forward?
We're conducting all of our criminal proceedings via teleconference or video conference. District and magistrate judges are conducting criminal proceedings. The majority of them are being conducted by video conference through video links we've set up with the Federal Detention Center. Their IT staff has worked with our IT staff and our court staff to be able to conduct those video hearings. And this eliminates the need to transport a person, a defendant, from the Federal Detention Center to the courthouse. The district and magistrate judges have access to a number of slots each day for video conferences and teleconferences, and they're using them. It's surprising how busy our criminal calendars are. In terms of reconstituting criminal proceedings as we move forward, it will be done slowly as we reoccupy the courthouses. I foresee a mix of in-person and remote hearings, and any in-person hearing would be conducted using safety measures including distancing, masks and face coverings, and some participants still connecting remotely to the proceeding.
So just from a practical standpoint, what do you recommend that criminal practitioners do now to ensure that these remote court proceedings are conducted smoothly?
Well, first, I want to say to all the practitioners, attorneys, thanks for your support and patience of our court as we work through our case management and conducting our proceedings. It's difficult for us, and I'm sure it's been difficult for you. We much prefer to see everyone in person, but right now it's just not possible to do that. If any attorney in any case, plans to participate in a remote video proceeding, please log on to our website and sign up for our training. We've learned that all these remote hearings take longer, and the quality of the hearing, the quality of the audio and the video is only as good as the remote connections of each participant. So make sure you test everything, make sure that you're dressed appropriately. I don't know if you heard about the judge in Florida that had a proceeding via Zoom, and one of the attorneys was in her bathing suit by her pool. So I think you have to treat it as if you're in the courtroom, and just be prepared that these hearings are going to take longer than normal, particularly when the defense attorney needs to confer with their client. We have a way for them to do that. We've also got a court reporter on the line, the judge, the deputy clerk, of course, the other attorneys are there. So it takes longer, and there's some coordination that needs to take place. So that's what I would recommend in the near term. In the far term, I think every attorney should learn to be adept at setting up their video proceedings for any court. I would suspect that many state courts and other federal courts are going to resume with audio and video hearings, and we just all need to get better at it.
Great, a lot of good advice. I pulled out my suit jacket for the first time in quite some time for this webinar. So looking now to civil cases, can you speak to the current status in our civil matters?
Sure. All of our judges are working their civil cases and keeping their deadlines in place. I was asked by the federal bar to work with Chief Judge Martinez to put together a letter to the federal bar members, and we're going to do that. And we're going to urge the practitioners to keep the cases moving forward. The flow of new civil cases has continued to almost pre-pandemic levels. If you can believe it, we had 544 civil and criminal cases assigned last month in our court, and that shows the bar is still very active in filing new cases. We're conducting our civil proceedings right now via teleconference, but we want to provide access to civil practitioners for video hearings very soon, and we're working on that. But the judges are actively managing their civil cases, and they're keeping their pretrial deadlines in place. So you can expect to hear, if you've got a pending case, from the judge or the courtroom deputy that we need to keep things moving.
So what, sort of similar to my question about criminal practitioners, what can civil practitioners do to ensure that court proceedings are conducted smoothly?
Well, the same advice I would give the criminal attorneys and any attorney that's going to appear remotely: to be patient, understand that these hearings are going to take longer, to test your audio and video connections, your background, how you appear on the screen, your camera settings, and then of course test your audio. In some instances, it's better to connect by telephone to the proceeding as opposed to using your computer audio. I mean, all of us are kind of captive to our bandwidth now. So you just have to be cognizant of those things, and then prepare for the proceeding as if you're going to be in the courtroom, because the proceeding is going to be as if it were in person.
So with the context that I think, and perhaps you can speak to this a bit more, but that civil jury trials are probably a ways off when you start thinking about the time to first start reconstituting jury trials, and then the criminal trials will take precedence. What steps is the court looking at, and what steps can practitioners take to help keep cases moving?
Well, for practitioners, I would suggest stick to the pretrial deadlines. When you get a scheduling order, that still remains in effect. Obviously, you can work with the judge and the other party to modify those deadlines, but when we issue a scheduling order, we want to stick to it. Granted, most scheduling orders in our court presume a firm trial date, and we're not able now to give everyone a firm trial date. But up to summary judgment deadlines, those are going to remain in effect. Each judge is working their cases very aggressively and trying to keep things moving. And as far as the fact that civil jury trials are way off, that's not just a function of the pandemic. As the bar is aware, we have 5 vacancies in our court for active district judgeships. All 5 of those now are termed as judicial emergencies. We have no active judges in Tacoma and only 2 out of the 5 in Seattle. So the fact that we're going to get backed up on civil jury trials is not just a function of the pandemic, it's a function of that we need new judges. Judge Martinez has been very aggressive working on this with Senator Murray's office and trying to work the process through the White House counsel's office. But it's not just a function of the pandemic that we see this coming on. We experienced it and we saw it coming before the pandemic, and the pandemic has only made it worse. But judges are trying as they can to set firm trial dates, and as soon as we reconstitute, you're going to see a lot more trial settings.
Great. So I understand that Judge Peckman is going to be holding a remote bench trial in June. Can you tell us a bit more about that?
Yes, it's going to be the first virtual civil bench trial in the history of our district, and we expect that it may be the first of many. Judge Peckman asked for the ability to conduct a civil bench trial, and our IT staff is working with her and the parties and our staff to make it happen. All the training will be done with the participants and all the testing will be done in advance. And it, of course, a trial, when you're used to in-person, you're used to exchanging evidence and objections and the flow of it, and that will be different in a virtual setting, but it will still be a civil bench trial and follow all the rules of procedure and evidence. Judge Peckman hopes to conduct the trial away from the courthouse. And I think the success of that will give us good guidance going forward. And this test is important because if it's successful, and I believe it will be, we want to use it for other civil bench trials. And I think this particular case is a perfect one because there's not a lot of witnesses and there won't be a lot of other people besides attorneys arguing, essentially. So it's a good test, and we want to make it successful and then perhaps try it with other civil bench trial proceedings.
Great. Do you know if, has there been a decision made about whether folks will be able to, the public will be able to observe that trial?
The public will be able to access the audio. We don't know about the video feed, and that of course is something that we're going to have to confront eventually, but we're going to make the audio feed available to listen only. And that's a challenge for us because right now, the Judicial Conference prohibits broadcasting and recording of our proceedings. But every proceeding that we conduct now, people can log in and listen to the audio proceeding, and we suspect that there may be violations of that policy, and that is a matter for our chief judge to confront if he chooses to. But really, if you think about an open court proceeding, our court has always been on the forefront of providing access. We were one of the initial pilot courts in the Cameras in the Courtroom project going back to 1994. We've been a participant in the Judicial Conference pilot project since 2011. We continue to participate, and we've signed up for the pilot program on broadcasting of audio proceedings. So maybe we're in this new era where courts and court proceedings are more readily available, and I think that's a good thing.
Great. So one question that I know we've heard a lot is how the court is handling emergency motions like TROs and the like in civil cases.
Sure.
You can speak to that.
Yeah, the procedure is really the same. If attorneys are aware they're going to file a TRO during business hours, it's helpful if they call us and alert us that it's coming, then we can alert the judges and the law clerks. If it's after hours, you just need to follow the procedures on our website. We have clerk's office staff on duty every night to handle emergency and TRO matters and work with the attorneys. Once we have something filed, then we can alert the chambers that it's there, and then the attorney can work with the judge. But I will caution you that many attorneys feel like what they have is truly an emergency matter, and it may or may not be depending on the nature of the proceeding. But please note that we have staff on duty ready to assist if it's after hours.
Thank you. I'm going to turn this over to Karen Orhosky, who's our co-chair of the Federal Bar Association Membership Committee, who has been monitoring the questions that have been coming in. And folks out there who are watching, please do continue to submit questions so that we can ask them. We have a wonderful opportunity here to hear directly from the court.
Thank you, Jamie. Bill, one of our first questions is about technology and for the remote hearings. Is there special technology that people will need, and what platform is the court using for the technology?
It's a good question. Right now, we're using the Cisco WebEx platform. It's a software that you can download onto your system. All of these products are essentially the same. Zoom, Jabber, Cisco, they all work the same in terms of how they interact and how the participants participate. We use WebEx because it is a judiciary licensed product and it's very secure. And Judge Martinez is a huge advocate of IT security, and we have always tried to pick the most secure products we can for our remote access. And so WebEx is the tool, and you can learn more about it through our website and logging in and testing it.
And do you know whether any of the chambers will be offering tests before hearings that they could do with staff members, perhaps, to make sure that the technology is working smoothly? Or is that something that will just be covered with the online training?
Well, both are available. What happens with the training is that you participate with our IT staff, and they test your connections. They can also, if it's going to be a trial or a longer proceeding, test with court members as if it were that type of proceeding. So we're used to extensive testing of these, but I will tell everyone, even with the best of testing, technical issues pop up all the time, and delays happen. People lose their connections. It's just stuff that would never happen in the courtroom happens with these remote proceedings. So you just have to test, and then once it happens, be patient. I was on a job interview with some staff on the other day from the courthouse, and my connection didn't work. So I had to connect by telephone. So even with the best of technology, sometimes it fails.
Thank you. The next question is, if you have a bench trial coming up, so a non-jury civil bench trial, what should you do about whether you know your case is going to go, or will the test run of Judge Peckman's trial tell us what the future looks like for those bench trials?
Well, that's a good question. As far as whether or not your particular trial will stick to that date, that's a matter between you and the other party and the assigned judge. But I believe that if Judge Peckman's trial is successful, that some of these civil bench trials that are set could be done remotely. Again, it's going to depend on the testing and the technology and the patience of the parties, but we would like to try anything we can to keep court cases moving. And as you can see, we're welcome and open to virtual proceedings, as long as they're secure and reliable.
And how are those witnesses being handled in Judge Peckman's trial, as far as swearing them in and where they are, whether they'll be referencing any documents? How is that being handled?
Karen, they're testing all the connections with the various parties and participants, including the witnesses. The swearing in would be done by the courtroom deputy, who will be on the proceeding remotely. As far as evidence and exchanging documents, that's the real tricky part that they're working on. I know that right now in my former district, the Northern District of Florida, Judge Robert Hinkle is doing a pretty complicated civil bench trial, and they've worked out all those procedures. So we're trying to capture all the best practices from around the country. This first one's going to be a little clunky, but it's going to be a good test, and we'll use our experience to make the experience better as we do more of these trials.
And Bill, how are you staying up to date with what all the other districts are doing? Are you keeping in touch with all of the court executives in the different districts across the country?
Yes, Judge Martinez and I are inundated with emails every day. Judge Martinez, being the chair of the Criminal Law Committee and a chief judge and member of the Judicial Council, gets more emails than I care to say, but all of it is very helpful. And there is a clerk's listserv that shares what all the experiences are. The unique thing about this pandemic, in my experience, is that we were the first court to issue an order. And we were one of the first courts to essentially close the courthouses and limit our proceedings. Many courts followed us in different states. Now some of those courts are reconstituting, and they're going to reconstitute before we do. So we're able to capture all those lessons learned from those other courts and apply them to our circumstances. I will tell you there are many differences in how courts will operate. One thing that's become pretty common in courts that are reconstituting is public health screening at the courthouse entrances, where they have public health professionals or contractors who are doing a non-contact temperature check and asking specific questions about exposure to COVID-19 and symptoms before they allow the person into the building. Our administrative office and their attorneys and our judges committees are looking at these practices. But what we've learned is this is kind of an essential part of ensuring the health and safety of everyone in the court process. So you can expect some kind of health screening to be done at our courthouse entrances. And it will also include for us a self-screening for each of our judges and our employees. It's just the way of the world now.
Thank you. Could you tell us a little bit about, for those who haven't had the opportunity to read Chief Judge Martinez's latest order, how things are evolving, and is there anything new in there of note that we need to know that changed from his last order?
Well, I've got Judge Martinez on the line. Judge, do you want to try and answer that for our audience?
Certainly, Bill. Thank you. I was just about to log off, and when I heard that last question, the general order basically follows the same pattern. We have to issue it every so often because of the speedy trial rules that we deal with, especially with criminal cases. We've basically maintained the same structure. Probably the newest aspect to it, though, is the mandate that everybody have to wear masks. And I think everything that we've learned about this virus is that it's transmitted mostly by person-to-person contact, with those little droplets that escape, from our mouths and our noses, just by breathing, just by talking, but mostly by talking. We're all familiar with what happened in that church choir out of Skagit County. That was terrible. An hour and a half practice with 60 people in a church setting, and I think 53 of those people ended up getting positive for COVID, and 2 of them died. That's also the concern in any enclosed setting with those little droplets in the air. So the mask, the purpose of the mask is to protect everyone else. Actually, the virus itself is so small, it can slip between the fibers of most of the masks, unless you're wearing one of those that are worn by, people in the health profession. But masks have been shown to basically eliminate 99% of any virus escaping from you, the wearer. So, the whole idea that we're having this kind of division in society about wearing a mask or not wearing a mask, basically it's like, if you wear your mask, you're protecting everyone else, especially if you're asymptomatic and you have even no clue that you might be sick or spreading the virus. So the main thing in this particular general order is to mandate that everyone that enters into our courthouses has to wear a mask in any of the common areas, in any of the public areas. Now, obviously, every judge has the authority and the ability to mandate how things are going to happen in chambers. But we have judicial discussions going on. In fact, I'm about to get on one here pretty soon, where we will be talking about trying to have some consistency even in that practice as well. For example, I've got 2 law clerks that have small children, and those children are now back in daycare settings. So every day those children will mingle with other children, come home to those law clerks then be coming into the courthouse. And I think it behooves everybody to keep those masks on until you know for sure that you are not symptomatic or in any way transmitting the virus. So that's basically the main difference from the prior, aside from keeping the timelines going.
Thank you, Chief Judge Martinez. How, and this is a question for Bill, has the way that people should contact chambers changed at all? Like, are there staff available for people if they have questions or if they're having discovery disputes?
You should contact the chambers through the main line. If it's not answered, they're checking their voicemail, they'll call you back. If you call the clerk's office and you talk to people, they're answering their phones using their computers. Of course, I'm always available to answer questions, and I'm happy to help out in any way. But if you look at our case management statistics and compare them to previous months, you wouldn't be able to tell that things are any different, except that not many criminal cases are being filed. Everything is still moving through the system, and remarkably, new case filings are very strong. So we're operating as best we can and as normally as we can, but it's almost all electronic.
And certainly, don't hesitate to use email. Electronic communication works the best, because in my chambers, for example, my judicial assistant, checks that email every single day. It's also checked by my courtroom deputy and also checked by my clerk. So there's several different people are looking at that as well as the phone lines, as Bill mentioned.
If people need to get working copies to judges, are those all being accepted electronically now?
Yes, with very few exceptions, and those are posted on our website. Our judges have been very accommodating with working from their computer screens. And that's of course a challenge for judges, because when you get a document over 50, 60, 70 pages, it's really hard to keep track of it without having a paper copy. But the judges have accommodated that need, and if you check our website, it'll give you each judge's preferences.
And here is a question about what considerations are being given to the effect of mandatory mask wearing to the ability of the hearing impaired attorneys or parties or others to participate in court proceedings.
If we get a request for an accommodation for hearing impaired, we will certainly accommodate it as best we can. We haven't had people come to court yet and use the masks, so we're going to have to test it out. But any issue that comes up, we'll deal with it fairly and completely.
So Karen, on a related issue to that, one of the things that I've seen from a national basis is, what do you do if you reconstitute a trial, even a bench trial? And are you going to mandate that the witness be masked? Isn't that a problem? And we have all quite aware of the demeanor of the witness from the stand is critical to the trier of fact, whether that's the judge or a jury. And are you going to have the witness masked in some way? How is that going to happen? With interpreters many times, they are watching the lips closely of the person that's speaking. They don't have to be hearing impaired simply from another language, and it's easier for them sometimes to be able to tell what someone may be saying at that point in time. All of these are going to be challenges that we're going to have to deal with. One of the potential suggestions that I've heard from other districts is maybe putting a plexiglass spit screen, the way you have in many of our grocery stores now, in front of the witness. So the witness can then take the mask off and be able to be seen by whoever's the trier of fact at that point in time. Of course, now you have to understand that puts the onus then on our staff. And say, for example, if I'm doing that and then a witness is done, then some staff person, probably my courtroom deputy, is going to have to step forward with disinfectant and wipes and everything and wipe everything down before the next witness can go in there. So we're learning as we go. Bill's comment earlier about some other districts are already starting up. I've heard that the Eastern District of New York, for example, had to have a grand jury convene in the last couple of weeks. It was just imperative because some statute of limitation issue. And because of that, they allowed the grand jurors to convene by video, which I think is the first time that's ever happened in the United States. So we're all learning as we go, and I'm sure you will see as we get back into it and start reconstituting our courts, you will see all these practices kind of shake out a little bit until we figure out what works, what doesn't work, what can be done, and what shouldn't be done.
And Chief Judge Martinez, this may be a question for you. Have you had any issues come up with statute of limitations and the inability to get parties served because of the COVID situation?
Not as of yet, but that is a major concern that's happening right now. One of the things, again, from and that's a national concern. One of the things that I hear from the national committees, and that's the beauty of serving on one of these national committees, is you're kind of tied into that, and you can see everything from a 30,000 foot view. But one of the things that's come up, for example, is both criminal rules and civil rules. They each have their own individual committees at the judicial conference level. They're both looking at potentially passing emergency rules. When the president declares a national emergency, that then gives those committees the specific authority to pass some temporary emergency rules. And they are considering a wide panoply of potential rule changes. So as a practitioner, you're going to have to be kind of on your toes to watch and see what starts happening as a result of any of those emergency rules that might come about. But statute of limitations issues, that's one of them. Service issues are definitely, on the table as well. All sorts of things like that. And maybe even you might see some emergency rules passed on how to handle some of these remote hearings a little differently. So we're all kind of waiting to see what happens and what comes out of those committees. By the way, those committees have begun meeting already, and they have to meet before the end of June. So it'll happen in the next 30 to 45 days at most.
Thank you. Now we have a question about our magistrate judges and mediations and whether they will be doing some of those remotely, or whether they have been doing those remotely.
Well, they are certainly welcome to schedule those with the magistrate judges. And usually that would be coordinated if it was a district judge case through the magistrate judges. But we have available to us other technologies that we could use for mediations that could be done over video, or they could even be done by teleconference. We're willing to employ any means to get cases to settle. And certainly if the parties want to seek that, they should contact the presiding judge in the case.
Thank you. I think I encourage the attendees to continue sending their questions in. Jamie, do you have any questions or any follow-up?
One question, picking up off of magistrate judges, I know that in the past couple of years, there's been a push to get civil cases in front of magistrate judges by consent. And I was wondering whether the court has given that process any thought, particularly in light of the backlog and what that might look like.
Bill, I can answer that. Yes, absolutely. We've given some thought to that. First of all, we've had some great success in being able to raise the consent rate for our magistrate judges. We have an excellent, field of magistrate judges, both in Tacoma and in Seattle. Very well experienced, very highly thought of, and can handle any kind of case. With the district judges being forced to push criminal trials down the line, if you will, that bow wave is building up. We have a concern that once we are able to reconstitute, it may be a while before we're able to handle some of the civil cases. Obviously, any one of our magistrate judges would be available to take any one of these cases, and they could give you a much quicker trial date since they can't handle our felony criminal cases for us. We may even have them, selecting juries if that's a potential, depending upon how fast we need to move through some of this. I've heard some suggestions on a national basis that we do jury selection, for example, remotely, like this. You can get on a Zoom call or WebEx or whatever platform you're using, do the selection process this way. This way, you don't bring in a large group of jurors to the courthouse. You only bring the jurors that are going to serve in that particular case. So rather than bringing 45 jurors in for a criminal case, I'm only going to bring in the 12 plus the 2 alternates, so bring in 14. And that would help too in terms of reducing the number of human beings having contact in the elevators, in the hallways, in the courtrooms, and however else we could space them out. So there's all sorts of things that are happening along those lines, but utilization of our magistrate judges would be one of the great ways if you're a civil practitioner and you need to get, an answer to your case, you need to get it tried, that's a great way of having it done.
Thank you. I think that covers most of the questions that have been submitted. Let's see. Yep. All right. Well, I want Chief Judge Martinez and Bill, are there any final remarks that you'd like to make?
Bill?
I would just say on the last question with respect to consent, we seek consent in all of our cases, and a certain percentage of our civil cases are assigned to magistrate judges for pre-consent. But even after we've asked for consent, if you want to consent to a magistrate judge at any point in the case, feel free to confer with the parties and go for it. Don't wait for us to ask. You can do it on your own motion.
And the last thing I want to say, first of all, is thanks again to the Federal Bar Association for your willingness to put this on and to allow us to communicate a little better to some of the people out there wondering what the heck is going on and when are we going to get back to some semblance of normalcy. As I said previously, maybe this is an opportunity. Maybe it's a great opportunity to look at the way things have always been done. And I mean, take a look at that. We have handled trials in basically the same exact way for what, 230 years. Think of what happened, last week with the Supreme Court, right? How many years has, CNN been fighting to try to get the Supreme Court to, open up their arguments so that the public could listen in? And that have been no. And then this virus did in 30 days what the, networks couldn't do in 30 years. Think about that. So if there are ways that we can look at doing things better to still be able to deliver justice and stuff, and you have an idea, don't be afraid to come forward. Maybe this is a great opportunity so that having gone through this pandemic won't all just be in vain, so that all the people that have suffered and are still continuing to suffer, there'll be something positive that comes out of this. But thank you to the Federal Bar Association once again for allowing us to join and maybe explain a little bit more to your listeners out there, and best of luck to everybody.
Well, thank you, Chief Judge Martinez and Bill McCool, for joining us today. And thanks to all of the participants. I'm already getting things popping up on chat expressing gratitude from the bar. So I know we all just really appreciate everything that you're doing to keep everyone safe and to keep our courts and our cases moving through these challenging times. Again, thanks to our participants, and please do join the Federal Bar Association if you're not a member, and renew in June when those reminders go out. If you have any questions or ideas about future programming, ideas for the court or anything like that, please do send those our way. Thank you so much. Take care, everyone.